Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers, trainers, professors, professionals, official listener learners. I welcome all respected doctors and directors. I welcome honorable ministry managers. I welcome adorable advocates, retired administrative advisors. I welcome the most honorable President Prime Minister Modi ji. Dr. Rakesh from USA, heartily cordially welcome. It is really nice time, nice place, nice section today that we are explaining, defining, expressing intervention. Trump says, ईरान हमले रुकने पर जवाबी हमले रोकेगा ईरानी विदेश मंत्री. Says स्टेट ऑफ हॉर्मुज अगले 2 हफ्ते खुला रहेगा. ईरान says. अमेरिकी राष्ट्रपति ट्रंप ने ईरान के साथ सीज फायर का ऐलान किया. राष्ट्रपति ट्रंप ने ट्रुथ सोशल पर किया सीज फायर का ऐलान. ईरान पर हमले पर 2 हफ्ते की रोक. ट्रंप सेज अपने सभी सैन्य लक्ष्यों को हासिल कर चुका है अमेरिका. ईरान हमले रुकने पर जवाबी हमले रोकेगा ईरानी विदेश मंत्री अरागची सेज. स्टेट ऑफ हॉर्मुज अगले 2 हफ्ते खुला रहेगा. ईरान सेज. अमेरिकी राष्ट्रपति ट्रंप ने ईरान के साथ सीज फायर का ऐलान किया. राष्ट्रपति ट्रंप ने ट्रुथ सोशल पर किया सीज फायर का ऐलान. ट्रंप से ईरान पर हमले पर 2 हफ्ते की रोक. अपने सभी सैन्य लक्ष्यों को हासिल कर चुका है अमेरिका. ट्रंप से ईरान हमले रुकने पर जवाबी हमले रोकेगा ईरानी विदेश मंत्री अरागची. Now let's go through our holy Indian spiritual, social, cultural, educational identities in the form of unity and diversity. Intervention. What's the meaning and definition of the word intervention? The word intervention has been defined as dictatorial interference by a state in the affairs of another state for the purpose of maintaining or altering the actual condition of things. In principle, international law prohibits intervention. The prohibition of intervention is the corollary of every state's right to sovereignty, territorial integrity, and political independence. But as pointed out by Hans Kelsen, international law does not prohibit intervention in all circumstances. According to him, when one state intervenes in the affairs of another state through laws, then as a reaction against this violation, international law permits intervention. In the view of Quincy Wright, intervention may be diplomatic as well as military. A diplomatic communication of peremptory or threatening tone, implying possible use of military or other coercive measures, may constitute intervention. The principle of non-intervention propounded under the Charter under Article 2.7 is applicable to the United Nations and not to the states. In fact, the principle of non-intervention by states has been propounded in Article 2.4 of the United Nations Charter. Article 2.4 runs as follows: all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. This principle has been reaffirmed by the General Assembly through its Resolution 2131 20 of December 1965. The principle of non intervention is in fact the search of an ideal of non interfere in the affairs of another state. The governments of states also accept this principle, but so far the real practice is concerned, this principle is not followed by the states. Dr. Thomas Frank has even propounded the death of Article 24 and proceeded to tell us who killed it. But as pointed out by Professor Louis Hankin, the death of certificate is premature and the indictment for legicide must be redrawn to change lessons to aggravated degrees of assault. Article 24 lives and while its condition is grave indeed, its maladies are not necessarily terminal. He adds, for me, if Article 24 were dead, indeed, I should have to conclude that it rules not mocks us from the grave. In fact, despite common misimpressions, Article 24 lives and can live. No government, no responsible official of a government has been prepared or has wished to pronounce it dead. Article 24 was written by a practical man who knew all about national interest. They believed the norms they legislated to be in their nation's interest and nothing that had happened in the past 25 years, now 59 years, suggests that it is not. In 1970, the General Assembly adopted unanimously a resolution entitled Declaration on Principles of International Law Concerning Friendly Relations and Cooperation among States in accordance with the Charter of the UN. The resolution declared every state has the duty to refrain from organizing, instigating, assisting, or participating in acts of civil strife or terrorist acts in another state or acquin- acquiescing in organized activities within its territory directed towards the commission of such acts. When the acts referred to in the present paragraph involve a threat or use of force, as regards the principle of non-intervention, the resolution added no state or group of state has the right to intervene directly or indirectly for any reason whatever in the internal or external affairs of any other state. Consequently, armed intervention and all other forms of interference or attempted threats against the personality of the state or against its political, economic, and cultural elements are in violation of international law. No state may use or encourage the use of economic, political, or any other type of measures to coerce another state in order to obtain from it the subordination of the exercise of its sovereign rights and to secure from its advantage of any kind. Also, no state shall organize, assist, foment, finance, incite, or tolerate subversive, terrorist, or armed activities directed towards the violent overthrow of the regime of another state or interfere in civil strife in another state. It has rightly remarked that the above resolution contains a far-reaching interpretation of the fundamental principle embodied in Article 2 of the Charter. For instance, the additional principles relating to the prohibition of the use of force make it clear that force may not be used not only across existing international boundaries but also across international lines of demarcation. That acts of involving the use of force are included in the prohibition. Further, it is noteworthy that the General Assembly declared further that the principles of the Charter, which are embodied in this declaration, constitute basic principles of international law and appeal to all states, including non-members, to be guided by these principles in their international conduct and to develop their mutual relations on the basis of the strict observance of these principles. This is but one important example of the legislative activity of the General Assembly, leading to the creation of new international applicable to all states. Thus, non interference in the internal affairs of states has become firmly established in international relations and international law as a fundamental and generally recognized principle. Reference may also be made to the Declaration on the enhancement of the effectiveness of the principle of refraining from the threat or use of force in international relations adopted by the General Assembly on 18 November 1987. This declaration solemnly declared. One is every state has the duty to refrain in its international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the UN. Such a threat or use of force constitutes a violation of international law and the Charter of the UN and entails international responsibility to is the principle of refraining from the threat or use of force in international relations is universal in character and is binding regardless of each state's political, economic, and social or cultural system or relations of alliance. No consideration, no consideration of whatever nature may be invoked to warrant resorting to the threat or use of force in violation of the Charter of the UN. For each states have the duty. States have the duty to not to urge, encourage, or assist other states to resort to the threat or use of force in violation of the Charter of the UN. However, states shall fulfill their obligations under international law in refrain from organizing, instigating, assisting, or participating in paramilitary, terrorist, or subversive acts, including acts of mercenaries in other states or accusing in organized activities within their territory directed towards commission of such acts. 6 states have the duty to abstain from armed intervention and all other forms of interference or attempted threats against the personality of the state or against its political, economic, and cultural elements. 7 is no state may use or encourage the use of economic, political, or any other type of measures to coerce another state in order to obtain from it the subordination of the exercise of sovereign rights and to secure from its advantages of any kind. It is in accordance with the purpose and principles of the UN states have the duty to refrain from propaganda for wars of aggression. The preamble of the above declaration of 18 November 1987 recalls that this principle is enshrined in Article 2, Propagate 4 of the Charter of the United Nations and has been reaffirmed in a number of international instruments and reaffirms the obligation to maintain international peace and security in conformity with the purposes of the United Nations. Thus, what has been stated above the Declaration of 1970 is also true of this declaration and may be regarded as authoritative interpretation of Article 2 for of the Charter or extension of the Charter itself. It uses the term use of force, which is definitely a much wider term. In case questioning military and paramilitary activities in and against Nicaragua 1986, Judge Nagendra Singh, who was then the president of the World Court, in his separate opinion, aptly remarked it represents the contribution to the court in emphasizing that the principle of non-use of the force belongs to the realm of just cogence and is the very cornerstone of the human effort to promote peace in a world torn by strife. This aspect does not need to be emphasized. Article 2 for Article 2 for and the limits of the use of force. Article 2 for has, as noted above, contains prohibition of the unilateral use of force or threat thereof by states in their international relations. The only exception of this recognized under the UN Charter is individual and collective self-defense as contained in Article 51, but in an article Reichman has given a very dangerous interpretation. He has tried to justify the use of force to oust a repressive government. He argues coercion should not be glorified, but is negative and indeed subversive of the public order. To insist that it never be used for coercion is a ubiquitous feature of all social life and a characteristic and independent indispensable component of law. The critical question in a decentralized system is not whether coercion has been applied, but whether it has been applied in support of or against community order and basic policies, and whether it was applied in ways whose net consequences include increased congruence with community goals and minimum order. He has suggested that while interpreting Article 2 for attention should be given to the spirit of Charter and not merely the letter of the provision. This is indeed a very dangerous interpretation of the Article 2.4 and must be refuted. Scattered has rightly refuted and criticized Richman's interpretation of Article 2.4. In his view, Richman's argument is not only against text of the Charter, it is also against the interpretation which states have given in the past decades. He has rightly remarked it would introduce a new normative basis for recourse to war and what that would give powerful state an almost unlimited right to overthrow government challenge to be responsive to the popular will or to the goal of self-determination. अयोध्या भी श्री राम लला की आरती का सीधा प्रसारण राम मंदिर से भगवान श्री राम की आरती का सीधा प्रसारण अयोध्या In the Corfu Channel case 1949, the UK had contended that it had used armed force in the cause of international justice, but such a contention was rejected by the International Court of Justice. According to Scatter, the fragility of international organization and hence the danger. This is surely not the time for international lawyers to weaken the principal normative restraint against the use of force. The world will not be made safe for democracy through new wars or invasions of the weak by the strong. Professor M. K. Nawaz has also refuted the interpretation of Article 2 for given by Reisman and has supported the views of Scatter. He has aptly remarked the upshot of all this is to say that no state under international law, especially the UN Charter, can intervene with armed forces either to change the existing government or to create political environment for instilling a government of its liking, nor can it so act militarily to suppress the processes of self-determination. The only exception being a state that cannot go to the aid of another state if an armed attack occurs against it, presumably at the request of the attacked state. So long as the words armed attack are retained in Article 51, this seems to be the correct interpretation of the Charter. This interpretation also finds support from the verdict of the International Court of Justice, indicating interim measures in case concerning military and paramilitary activities in and against Nicaragua and United States of America. The word court held by majority of 14 votes to 1 the right to sovereignty and to a political independence possessed by the Republic of Nicaragua like any other state of the region or one or the state world should be fully respected and should not be any way be jeopardized by any military and paramilitary activities which are prohibited by the principles of international law, in particular the principle that states should refrain in their international relations from the threat or use of force against the territorial integrity or the political independence of any states, and the principle concerning the duty not to intervene in matters within the domestic jurisdiction of a state, principles embodied in the United Nations Charter and the Charter of the Organization of American States. It may be noted that outlining the policy of US in Nicaragua, President Reagan openly declared that unless the Nicaraguan government sought democracy, the only other alternative for the rebels would be to have their way and take over. With this policy in view, the US was giving $10 million military aid to Contras. But as rightly indicated by the International Court of Justice in its final verdict in June 1986, by a majority of 12 to 3 was the aiding of Contra rebels with money and military hardware. US supported attacks on Nicaraguan ports and oil installations, and US intelligence flights over Nicaraguan territory constituted an infringement of Nicaragua's sovereignty and a flagrant violation of the principles of the UN Charter, which ban unlawful use of force by one state against another. The World Court held that there is no rule in customary international law permitting another state the right of collective self-defense on the basis of its own assessment of the situation where collective self-defense is involved. It is to be expected that the state for whose benefit this right is used will have declared itself to be the victim of an armed attack, whether the unlawful of the use of collective self-defense by the third state for the benefit of the attacked state also depends on a request addressed by that state to the third state. The requirement of a request by the state which is the victim of the alleged attack is additional to the requirement that such a state should have declared itself to have been attacked. This case clearly illustrates the dangers involved in Eastman's thesis about Article 2.4. The interpretation given by Snecter and Professor Nawaz is correct and has much to comment itself. Reference may also be made here to recent case of International Court of Justice, namely case of concerning legality of use of force Yugoslavia versus United States of America. It may be noted here that on 29 April 1999, Yugoslavia filed as many as 10 separate applications instituting proceedings against the US, the UK, Spain, Portugal, and Netherlands, Italy, Germany, France, Canada, and Belgium, alleging that they were guilty for violation of the obligation not to use force and requested for the indication of provisions measures. The above case is one of the 10 cases the International Court of Justice rejected the request for indication of provisional measures on the ground that in the absence of the consent by the United States, the court cannot exercise jurisdiction. The court ordered that the case may be removed from the list. However, the word court remarked, whereas there is a fundamental distinction between the question of the acceptance by a state of the court's jurisdiction and the compatibility of particular acts with international law. The former requires consent, the latter question can only be reached when the court deals with merits after having established its jurisdiction and having heard full legal arguments by both parties. Further, whereas whether or not states accept the jurisdiction of the court, they remain in any event responsible for acts attributable to them that violate international law, including humanitarian law, whereas any disputes relating to the legality of such acts are required to be resolved by peaceful means, the choice of which, pursuant to Article 33 of the Charter, is left to the parties. In this context, the word court asked the parties that they should take care not to aggravate or extend the dispute. Lastly, the court observed, whereas when such a dispute gives rise to a threat to the peace, breach of the peace, or act of aggression, the Security Council has social special responsibilities under the Chapter 7 of the Charter. 31. Grounds of intervention. The coming into force of the Charter of the UN has brought about revolutionary changes regarding the valid grounds of intervention. Most of the traditional grounds have ceased to be valid. The Charter has, however, introduced a new ground, namely collective measures or collective intervention founded on the concept of collective security. Broadly speaking, there are no, now only two valid grounds of intervention, one for the states, that is self defense, and the other for the United Nations, that is collective intervention or enforcement action under Chapter 7 of the Charter. A critical discussion of the following grounds is being undertaken with a view to which of these grounds are still valid. Self One is self defense, two is on humanitarian grounds, is to enforce treaty rights, for his intervention to prevent illegal intervention, 5 is balance of power, 6 is for protection of persons and their property, 7 is collective intervention, 8 is intervention to maintain international law, and 9 is intervention in civil wars. Self-defense has been a valid ground of intervention for a long time. On the ground of self-defense, a state may intervene in the affairs of another state. In this connection, Mr. Webster, the Secretary of the United States of America, propounded a very important principle in the famous case, the Caroline 1841. In this case, Mr. Webster declared that the necessity of self-defense should be instant, overwhelming, and leaving no choice of means and no moment for deliberation. This principle was affirmed by Nuremberg Tribunal in 1946. The test laid down in the Caroline was finally affirmed by the International Court of Justice in the Corfu Channel case. The facts of the Caroline case are as follows. In Canada, which was then the colony of Britain, some revolutionaries were trying to overthrow the government. The ship named Caroline was carrying arms and men from across the river Niagara within the territory of America to assist the rebels. The British government lodged a protest against the American government, but with no effect. Consequently, the British soldiers crossed the river, seized seized the ship in the American territory and left it floating. The American government protested and asked the British government to justify its action on the ground of self-defense and self-preservation. The American Secretary of State, Mr. Webster, propounded the above-mentioned test. England failed to justify its action on the basis of this test and had to express regrets. The facts of the Corfu Channel case 1949 are as follows. North Corfu Channel is between Albania and Greece. A part of it is within the maritime belt of Albania before May 1946. The British ships had removed the mines from the channel and had ensured that it was safe for the passage of ships. That very month, some British ships were fired at from the territory of Albania, resulting in damage to the ships. In addition to this, after some time, the British ships suffered loss and damages due to mines which were laid in the territorial waters of Albania. This also resulted in the loss of lives of some person. Consequently, the British ships removed mines and explosive substance from the shared portion without seeking permission of the Albania government in this connection. Albania protested against this and contended that it was a clear violation of Albania's sovereignty. On the other hand, due to the loss and damage to the British ship by mines laid down by Albania, Britain raised this matter in the Security Council. The Security Council advised Albania and Britain to refer this matter to the International Court of Justice. In the beginning, Albania raised the objection in regard to the jurisdiction of the International Court of Justice in this matter. The International Court of Justice rejected the objection of Albania. Ultimately, Britain and Albania agreed to refer the matter of the International Court of the Justice for adjudication. Albania and Britain entered into the special agreement, and so this agreement referred the following two questions for adjudication of the court. One was Albania liable under international law for explosions in its maritime belt, and if the answer is yes, whether Albania is liable to pay damage for the same. Two is whether Britain violated the sovereignty of Albania by removing the explosive substance, mines, etc. from the territorial waters of Albania. The International Court of Justice answered the first question in favor of Britain, that is to say, the court decided that Albania was responsible for explosions in its territorial waters. The court answered the second question in favor of Albania. This is to say, Britain violated the sovereignty of Albania by removing the explosive substances from the territorial waters of Albania without its permission. The court observed that Albania was under an obligation to inform Britain about the mines and explosive substance in the North Shore Corfu Channel. Albania did not give any such warning to the warships of Britain. In addition to this, no such endeavor was made by Albania as might prevent the harm caused to the warships of Britain. The court therefore ruled that Albania was liable for the loss and damage caused to the British warships on count of explosions and was also liable to pay compensation to Britain. The court observed, it is generally recognized and in accordance with international customs that states in times of peace have a right to send their warships to states used for international navigation between two parts of the high seas without the previous authorization of the coastal state, provided that passage is innocent, unless otherwise prescribed in an international convention. There is no right for a coastal state to prohibit and with such passage through straits in time of peace. But by removing mine etc. from the territorial waters of Albania without its permission, Britain was guilty of the violation of Albanian sovereignty. However, in view of the gravity of the Albanian act of firing on British ships, the World Court did not award any compensation on this account. The test propounded by Mr. Avastar is still valid with the only difference that intervention on the ground of self-preservation is no more allowed. Thus, instead of self-defense and self-preservation, the valid ground now is only self-defense, that too very much limited and curtailed by Article 51 of the Charter of the UN. However, the concept of self-defense as expounded under Article 51 includes the defense of others and is called the right of individual and collective self-defense. The United Nations Charter enshrines the principle of individuals and collective self-defense in Article 51. Article 51 provides nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken the measures to maintain international peace and security. Measures taken by members in exercise of this right shall be immediately reported to the Security Council and shall not in any effect the authority and responsibility of the Security Council under the present charter to take at any time such action as it deems necessary in order to maintain or restore international peace and security. The right of self-defense under Article 51 is subject to following conditions. One is there should be an armed attack. Two is the right exists until Security Council has taken any action. Three is it should be reported to the Security Council for it is subject to the review by Security Council. Five, this right shall not affect the responsibility of the Security Council for the maintenance of peace and security. The right is not available against a non-member of the United Nations. Thus, the beginning of an armed attack is condition precedent for resort to force in self-defense. This may be explained with the help of the following illustrations. First is the state receives information that its neighbor state B is preparing to invalidate its treasury. In order to forestall the invasion attacks B and preparing to invade the territory in order to forestall the invasion A attacks B and disperses the troops amassed in B. A and B are both members of the UN. B brings a complaint against A in the Security Council that state A has committed aggression. A pleads self-defense. Similarly, the territories of a big and powerful state X lie between the territories of two small states A and B state. A is towards the east and the state B is towards the west of the state X. After certain border incidents during the course of which a few soldiers belonging to each of the three states were killed and wounded, the state X attacked states A and B and occupied major portions of their territories. The Security Council tried to intervene, but the reply was given by the state X was that the state A and B were about to attack X and the latter had started military operation in order to protect its interest. The state X also contended that it alone could determine whether or not such danger existed. In illustration, one is intervention by state A is not justified under Article 51 of the Charter. Similarly, in illustration, two intervention by X is also not justified because Article 51 of the Charter permits the right of self-defense only if an armed attack occurs against a member of the United Nations. In both the above illustrations, armed attack has not taken place, but the contention was that preparation were being made to launch the attack. Moreover, in the second illustration, Axis contention that it alone could determine whether or not such danger existed is not justified because Article 51 of the Charter clearly provides that measures taken by members in exercise of this right shall not in any way affect the authority and responsibility of the Security Council under the present charter to take it any time such action as it deems necessary to maintain or restore international peace and security. I thank all my brothers and sisters, ladies and gentlemen, students, scholars, teachers, trainers, professors, professionals, officer, official, listener, learner. I thank respected doctors and director. I thank all the listeners of YouTube चैनल 3M क्रिएटर्स। पिछले 24 घंटों के दौरान खाड़ी क्षेत्र से 12 में भारतीय नाविक 28 फरवरी से अब तक क्षेत्र से 7.6 लाख यात्री भारत लौटे। भारत ने परमाणु ऊर्जा कार्यक्रम में हासिल की ऐतिहासिक उपलब्धि। स्वदेशी प्रोटोटाइप फास्ट ब्रीडर रिएक्टर ने हासिल की फर्स्ट। कल्पक्कम स्थित 500 मेगावाट क्षमता वाले संयंत्र में हुआ परीक्षण, तमिलनाडु।